Hi, welcome to My Court Coach. I'm Jaylyn and I'm going to be your instructor as we navigate through Form DV-400, Findings in Order to Terminate Restraining Order After Hearing. So, when do we use this form? When the court actually does terminate your restraining order after your domestic violence restraining order hearing. So the court has to make findings that, well, we'll get through those findings in a second, but the court has to make these findings in order for it to actually terminate your restraining order after hearing. And this is not to terminate your temporary restraining order. This is to terminate your permanent restraining order. Why would you want to terminate your permanent restraining order? That's really a personal decision. Perhaps you and the other party have reconciled. They've turned a new leaf after going through many therapy sessions and anger management programs, and they've just decided that they wanted to become a better person to you, and especially if you guys have kids, to your kids, and now things are significantly better where it's worth giving it another shot. That could be a reason why to do it. Or child support. If your spouse or significant other is a nurse or something in the healthcare field, and now that they have this restraining order on their record and they're going to be let go unless this restraining order is removed from their record, and therefore if it's not removed, then they're going to lose their job, and therefore you're not going to get child support, you may not get spousal support, and now you're essentially reducing your financial loss from the other party, and you're kind of at a loss as to what to do, especially since that other person was your primary, not caretaker, but breadwinner. So if you lose that because of the restraining order, then you have to make some very difficult decisions there. So let's get through this one. So complete only items 1 and 2, the remaining items are for court use. Name of protected party, so you're gonna write your name or the name of the protected party. The name of the restrained party, so either your name or the name of the alleged abuser or the abuser, since the court found that, since there is a restraining order after hearing. The court findings, so the court has to find either that the protected party filed the request to terminate the restraining order after hearing, and a proof of service by mail or personal service of the request on the restrained party is filed with the court. So it's very important that the proof of service is filed with the court. So the request to terminate the restraining order has to be filed with the court. The restrained party filed the request to terminate restraining orders and filed the proof of service showing that the protected party received notice of that request by personal service, service on the Secretary of State, so the protected person is registered at the Safe at Home program because their address is confidential, or an alternative court-ordered method of service that gives actual notice of the request and the hearing. The restrained party filed the request to terminate the restraining order. The protected party was physically present in court on the hearing date, waived his or her right to notice, and does not challenge the sufficiency of the notice. The protected party was physically present at the hearing and verified his or her identity. The protected party and the restrained party submitted a written stipulation to terminate the restraining order or some other findings. Court orders. So the court is going to establish that the protective orders in the restraining order after hearing that were issued or modified on specified dates, the date that it was filed, is terminated. This order is going to be effective when the court actually has a date on there. The child custody and visitation and child support orders in that restraining order after hearing can remain in effect. They can be modified, or they could also be terminated. Spousal or domestic partner support orders in a restraining order after hearing can also remain in effect. They can be modified or also terminated. Unless modified or terminated by court order, any existing orders for custody, visitation, child support, spousal support made in the Domestic Violence Prevention Act case after a noticed hearing survive the termination of the protective order and remain in effect. This order does not modify or terminate any existing criminal, juvenile, or probate court orders. So the court is essentially saying, going back to 4C, is that after this noticed hearing, the court orders, the existing court orders for custody and visitation and support, those are going to still stay in place even if your restraining order is terminated. So unless the court terminates it, the court is going to maintain those orders. And so it essentially explains what it is the court is ordering in A or B. And even if the restraining order is terminated, then your child custody support orders, those can still be in place regardless of the termination of the restraining order. We hope that you have found this helpful, and good luck.